And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show here on CIL 650 with a little We Are Family going on in the background. A very appropriate song to start the program with today because our guests in studio are from Westside Family Law. A pleasure to welcome Mark Perry back to the show. Hello, Mark.
Hi, Sterling. How are you?
I'm very well, thanks. And introduce your associate to our audience. Jessica's making a first appearance on the program.
Yes, her first appearance. Not her last, I'm sure.
I will definitely think not.
This is our senior associate, JessicaEngland.
Jessica, welcome.
Hi, Sterling. Thanks for having me.
You're a Toronto kid who came to Vancouver, got a law degree at UBC, and you haven't left since you graduated.
That's correct. I don't plan on it either.
Why did you choose family law, Jessica? What pulled you in that direction? Given at law school you have the full spectrum to make a choice from, what drew you to family law?
I love working with people. It's the most interesting area, I think, because we're dealing with issues that really matter to ordinary people. And that's what I like about it.
Okay, so it's a people business,
yes.
And you're right there in the front of the front lines, too, aren't you?
Very much so.
And we'll talk a lot about people issues here. But, Mark, on your very lengthy bio, it does point out that you've been a lawyer for 25 years. You've also been, they say you're a respected litigator and mediator. What's the difference between a litigator and a mediator?
Well, it's probably easier to define litigator. A litigator basically means a lawyer who goes to court, presents a case in front of a judge,
okay,
and seeks from a judge a finding in favor of the client.
Right.
Whereas a mediator, or as a mediator, I am assisting parties trying to resolve a dispute on an alternate dispute resolution sort of basis.
Okay. So do you, as a mediator, perform kind of the role a judge would?
Not really. A judge hears evidence and makes determinations as to what the facts are and then decides.
Okay, and you don't have to decide. You want the parties to decide, right?
That's basically right. Yes, it's as a mediator, it's often trying to draw out from both sides common sort of elements to the story,
right,
and to support both sides in coming up with a solution. So it's facilitating a discussion. It's attempting to help them come up with a way to resolve whatever is in dispute.
Jessica, as you've come into the profession, this transformation has been underway big time. 10 years ago, Mark was just learning about mediation. Now he's a veteran at it. But this whole notion of something other than appearing in front of a judge to resolve family matters was right. The big changes were occurring as you were in school, right?
That's correct, and I think that it's a change for the better because, as many of your listeners may know, litigation is extremely expensive.
Yes.
And sometimes you don't get the outcome that you wanted or anticipated, and mediation allows the parties to have a greater measure of control over the outcome.
Right.
And
right.
that's particularly important when you're talking about family matters. For example, what we're talking about today with children, parenting schedules.
Sure.
They want to have more control over what that looks like.
Right. And is this all about the push behind the collaborative law, the inclusion of mediators, Mark, in the process? Is it more about fairness, or is it as much about taking some of the workload off the courts?
I think it's both, frankly. I think it's both. It certainly is not just in family law that the courts are introducing a lot more processes that are designed to divert cases from being in front of a judge.
Okay.
But on a fairness basis, absolutely, it will enhance outcomes that make sense for both people.
Mm-hmm.
And what I think about when I talk about mediation is when you go in front of a judge, sometimes the outcome annoys both sides.
Well, that's it. That's it.
and the biblical story of King Solomon is really sort of what can possibly happen.
Sure.
We're not dissecting a child here. But you can get an outcome that both sides are very unhappy with.
Right.
Whereas in mediation, you build something together.
Right. And Jessica, you've referred to exactly the same thing. So the danger in going to court, in being aggressive, I guess is one way of putting it, and being absolutely determined to be heard by a judge, is that at the end of that day, the judge may not find in favor of you, in which case you lose pretty much everything, don't you?
That's correct. That's correct. And there are
So it's higher risk, isn't it?
It's absolutely higher risk, and there are things that make it going to court ill-suited in the case of family law specifically, especially when you're speaking about children. When you get to the point where you're considering going forward to trial and you book that date, it might be 1 year from now, sometimes greater than 1 year. Now again, when we're talking about children, 1 year in a child's life, that's a very long time to have things unsettled.
True.
Now you go to mediation and maybe you can come to an agreement earlier, and like we said, that suits your needs and the child's needs better. Now, having said that, I should say sometimes litigation is just necessary.
Sure.
Absolutely.
Would
and
that
it's
be
a good thing.
mostly, Jessica? Would that be because of the just blatant hostility on both sides? Would that be sometimes you just got to take this to trial because nobody's going to be reasonable here?
Yes, that would be one of the cases. I would say so. Yes, and in that case, it could actually be more expensive to continue trying to find a resolution between the parties.
Right.
Right.
But
I would add to that, though, it certainly hostility would be a factor.
Sure.
That would make perhaps litigation a more viable option. But it's not even just hostility. It could certainly just be people's perception of reality being diametrically opposite. And there isn't a way of sort of breaching that gap. So they perceive things very, very differently.
Sure.
And really, that's really where a judge comes in, because we drew the distinction between a mediator and a judge.
Right.
A judge determines what the facts are.
Right. And once the judge's decision is rendered, that's it. That's what you
it.
have to live with.
That's right.
Right.
Yeah.
What about pressure? Because, Jessica, you were talking moments ago about, the fact that some of these negotiations, to try and put a nice smile on it, last an extended period of time, for a year or longer. What about pressure to resolve these matters more quickly, Mark? To Jessica's point about a year in the life of a small person is a terribly long time to be basically in legal limbo. So how about that in terms of pressure from the system to the adults, at least in this equation, to get things done?
Right. Well, there's a couple things to just include in that answer to that question. One is, while the trial may be a year away, the parties, the parents have the ability to apply for an interim court order.
Okay.
Or they can arrange an interim agreement. So before the final decision is made, there is something put into place. And that's typical.
Okay.
Right? So that reduces some of the pressure.
And would that be
not as much a legal limbo?
Would that be negotiated between the two lawyers representing the two parents?
Generally, yes.
Okay.
Yeah.
So the judge doesn't need to become
But
involved.
a judge can make an interim order as well.
It can impose one.
Yes.
Again, in the face of considerable hostility.
That's
right.
right. Yeah.
I guess in a lot of cases, I would think in a lot of cases, and we touched on this when you were last with us, Mark, a big part of the job, especially in the early days of getting to know the client, has to be talking people down from a pretty fevered emotional pitch that isn't particularly beneficial for anyone. And yet, you can certainly understand why they're that cranked up.
Oh, absolutely. Yes. Yeah. No, that is a big part of what we do. That's listening to people.
Yeah.
Validating what we're hearing, empathizing with what they're going through. But there's a point during that discussion, and I've done this for so long, I sort of know where that point is,
Sure.
where you're validating and empathizing with what they're going through, but then starting to steer that person towards an understanding, normalizing what's going on, to encourage some reasonableness, and you're building on that. And then you have a client that is going to be amenable to a negotiated resolution.
Are there
a client who's going to see the other side not as Satan's spawn.
Right, exactly. But
sometimes I remind them, you married Satan's
that's
spawn.
right, exactly, yeah. At one point, he was okay.
Yeah, or she was okay.
That's
So,
right.
let's be realistic here. And when, again, we're talking about custody guardianship issues with children, reminding a client that the other party, the other spouse, will always be a parent to that child.
Right.
And the best solution here is always going to be finding some common ground and be able to parent together in separate households.
Are these matters of hostility predictable from a lawyer's perspective? This for both of you. For example, is there an area of that is likely to produce a more hostile dissolution of the relationship? Infidelity, for example, would likely be a red flag for a lot of relationships that would cause considerable hostility. Is that the case, Mark? Is it
Sure.
Is it usually
Absolutely.
something that blatant?
Yeah. Definitely infidelity, adultery is a significant issue for many people.
Right.
That causes a lot of hurt and anger and hostility.
Right.
Absolutely.
Right.
Yeah.
But I guess, though, Jessica, what was it like the first time you had a client in your office of either gender who was so put off and so angry and so hurt that the only thing they wanted to do was hurt the other person as badly as they were feeling at that moment sitting across the desk from you?
Mm-hmm.
How do you talk somebody down from that point?
Well, first, I think you have to empathize. I mean, we're meeting people really in the worst time in their lives, without a doubt. I don't think that's an overstatement at all.
I don't think so at all.
And, after empathizing and understanding how they feel and what they've been through, I think you have to help them to understand that if the focus is to hurt the other person, they're ultimately going to be hurting themselves, and again, if there are children involved, hurting their family as well. So it becomes your role to help them move past that and see what is in their best interests and in their children's best interests.
And I suppose, Mark, there comes a time where there's the odd client who just doesn't get that, who just wants to inflict harm, in which case you probably advise them to go see another lawyer, right?
Actually, before I might do that, and not necessarily in the very first interview, as Jessica says, we're empathizing and understanding what we're hearing, but somewhere early on in the process, I certainly might say to the person, so the outcome you're seeking, which is to inflict harm on the other side or cause the other consternation, here's the dollar amount that you'll pay
right.
to achieve that.
Right.
And that has a very sobering effect with most people.
I'm sure it does.
So from that, I perhaps have a person a bit more open to hearing about some of the other options, both procedurally and just, what Jessica's spoken about, hearing about how that revenge is not necessarily their interest, their pocketbook's interest, or certainly their children's interest.
We're talking with Mark Perry and Jessica England from Westside Family Law on this episode of The Law Show here on CIL 650. And one of the issues that we wanted to get into this morning was guardianship and custody. What, Jessica, is the difference, if any, between those two terms, guardianship and custody?
Boy, I'm glad he's asked you, not me.
Or do they mean the same thing?
They are certainly related. Custody was the old term under the Divorce Act.
Okay.
And also under the Family Relations Act, which is now being replaced by the Family Law Act. Now, that term is still used in relation to the Divorce Act, which is the federal legislation that only applies to married couples. Okay. Now, under the new provincial legislation, the Family Law Act, we use this term of guardianship, which refers to a a number of rights that the parties have, that usually the parents exercise,
Right.
to make decisions concerning the child. Okay, so maybe about who they're going to associate with, where they are going to reside, where are they going to go to school,
Sure.
and then everyday things like getting passports and things like that. Now, guardians exercise parental responsibilities. So this is very different than under the old Act. And just importantly, they have to exercise these parental responsibilities in such a way that they are in the best interest of the child. So the new Act is very child-focused.
Okay, so the big difference between guardianship and custody, as I'm understanding it, is basically new law, and so therefore new legal language as much as anything else.
That's probably accurate. Yes.
Okay.
Yes.
So guys who've been around the block a couple of times like you are probably going to lean on the word custody, more so than people like Jessica, a little more recently graduated from law school, who's going to lean in the general direction of guardianship.
Every morning when I get up, I say guardianship 100 times to try to stop using the term custody. But it's not working, so, you know.
Okay, well, we're going to talk about guardianship and or custody when we return after these messages on The Law Show here on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.